Manever I say ma PENDREAM TV. PENDREAM TV there, o see them yopo.
Bra Kwame, make me can say Enwa Supreme Court by a 4-1 majority decision. I can say Omone the MP for Kpandai, Honorable Matthew Nyindam, Sebi, on remaining as the Member of Parliament elect for the good people of Kpandai. Kwame, some interest, said Matthew Nyindam, the papa in the air concomani, but the mammy in Chumruni, so Nza.
One papa na concomani.
Yindam, MP for Kpandai, Yindam.
Wow, minimum
and the mammy in Chumruni.
Okay.
Okay. The one who said Oti region is one of the major tribes in Chumrufo.
Chumrufo, yeah, no.
And the part if the northern region and the part in so I work close with Oti.
Okay.
Now, Kwame, would you say Kpandai a traditional NDC seat?
Sana a history in its own.
Oh yeah, a traditional NDC seat. It will share for a long time. I think for 20 years. Now NDC in the Dasso. At that time, the late Honorable Kojo Taya Likbalimo in an MP. For your MP now, I think for 20 years. The only person put me a breaking that jeans. Matthew Nyindam. And Osha Kpandai a typical Konkomba Nanumba in Chumuru community. Now, because Ono Nema mi akoye nchumuru ni ena ne papa akoye konkoma ni no with me into the NDC base inti na akoye so wakonya advantage kakra bi wo ono inti wo hwe ya obeye MP ena obiti tawia le parlement ena Yabeji ye seat bio in 2024. Waya sade no wa be chemu bio. Na no na ba to no wie ye no. Na ye kan ti o ye ne nya adwen. Nti as usual, ya invoke the High Court jurisdiction to hear an election petition. Now, Kwame, this is where it gets interesting. Nti based on a 24th December purported gazette of the election results. And I may take the timeline very way. 24th December.
24th December.
2024. Electoral Commission at the gazette be at the buy. That gazette no ye jina asono. Any file a parliamentary election petition because Article 94 and NDC Law 284 representation of the people's law. I can say who makes me the parliamentary election petition at the about 21 days after the gazette of the election and not before. The Supreme Court in several cases I can say when you file a parliamentary election petition prior to the gazette notification, the action will be considered premature and will therefore be struck out.
Yeah, because the gazette here won't mean
court.
Sure.
Based on that 24th December purported gazetting, no, Brakwame, ye court at the High Court in Senior Friend Tamale. But you now, ye court in Tamale, no. In a Matunindam, a man, a lawyer for a filing a motion or notice raising preliminary legal objection. Preliminary legal objection. What was the nature of the objection? Bakwame. The objection is to the effect is say the NDC candidates no have a court premature, and that the actual gazette a year 6 January 2025, and so the date on that gazette notification is 6 January 2025. And so, based on the argument he made in court, no, per the motion now of filing, no, not the okay in an say 6 January 2024, in the date for the gazette there, and the action mounted by the NDC candidate at the High Court in Tamale was premature. Machoteniyo. Inti NDC candidate knew who he are. In fact, he filed a motion, and accompanying the motion was an affidavit. That affidavit, no, or no, Matunyinda Mankasa in the deposit to the affidavit, and he took an oath. Ocean the deposition now. Mekaipa say ocean the depositions now. Okay, in the deposition say the day of the gazette, 6 January 2025. In the NDC candidate knew who Sanan was so okay. Say 6 January, yeah, and that is the date you think was the gazette notification, yeah. The rule says I have 21 days. In that 21 days now, all can one no. I'm still within the range, even if you calculate from the 6th of January. That's what I mean by what here.
Meet you, Honorable.
Good. In the NDC candidate, no, quickly or withdraw the initial petition of filing, you know, because now the respondent agrees to say 6 January and not 24th December. So based on that, you withdraw your initial petition. You withdraw, and of course, you say, you can't just withdraw like that. Cancel. So I am awarding cost. I think it was 10,000 cedis. Share what back cost without blah blah blah. No, you pay what they mean using colloquially a cost or penalty of 10,000 Ghana cedis. And yes, you okay. If you withdraw, now that you say a 6 January, we are still within the 21 days. And I file a fresh petition. And the fresh petition now you file a High Court SSA the issue down for trial. NDC for witnesses Ebra. Electoral Commission for witnesses Ebra. Marching down also for witnesses Ebra. And now judge go through a full trial. A full trial. If the judge go through a full trial now, on man the decision, no. A Koba say, said you, Yenya Martin Dam. Now a Koba say, you declare the seat is vacant. Now you order for re-election or rerun of the election. The aftermath of it, no, is a matter of public record. Nti Ekobasa from nowhere na Martin said no. Sebio, the proper date for the Gazette December. The original date now NDC candidates no using you know. That is the proper date of the Gazette. And not the 6th January now on no High Court judge now what deposit to affidavit. No. That is not it. That's why I mean this is where it gets intriguing. Because what in our call High Court judge no what tamale say the initial petitioner NDC candidate no mountain you know premature. And because it is premature, you think A, B, C, D ought to be done. In the year withdraw your petition. And I file a fresh one. Based on the new date now, what your court say, that should be the date that the court should be using. And not the 24th. I say, based on that your 6th January, you bring in a fresh action. Which a fresh action, no, you are litigating judgment about. Now, since the judgment didn't go in your favor, no, why a 360 degree say, oh, that 24th December now, NDC candidate in UZ, no, that is actually the proper date, and not your 24th, and not the 24th winner. NDC candidate, you know, at the buyer. And I say, what's that? What is happening? You can't eat your cake and still have it. Well, in our day application at the bar court, at the country court, you say, the date for Gazette is 6th January. And in fact, that's funny. We share affidavit now, or yeah now. On one case, ejina mu can say, oh, as far as he is concerned, the 6th January, that is the proper date for the Gazette notification. And we said, okay, if this is what you are saying, since we are within time, we will withdraw the petition, and the court awarded cost against us. Based on that cost implication, in Aja, the two and among, Obeka say, yeah, then in the two, sir. Now, also on one affidavit now or the bar court now. This is essentially what he says, and I just want to read for our listeners. Paragraph 8 of the affidavit in support of the motion to strike out, sworn to by Martin Yundam himself, also quote, that available records show that the parliamentary election results of the December 7th, 2024 election nationwide, including that of Kpandai constituency, were published in the Gazette or gazetted by the Electoral Commission on 6th January 2025. Attached here to and marked as Exhibit JS3 is a copy of the page of the Gazette notification of the parliamentary election results. Show is even profound. That list shall be sought to send the soft copy of the full Gazette to this court. Paragraph 8 of Onwa ne affidavit in support of the motion to strike out the petition as premature. It is based on this way, in fact, also the Gazette notification that he attached, INA Exhibit JS3 now, it says Ghana Gazette, 6th January 2025, Electoral Commission Ghana, detailed parliamentary election results, date of region, northern region, SN number, name of candidate, Matthew Yindam, Daniel Nsala Wakpa, and Donko Eric Nipani, and Obiani results. It is based on this na NDC candidate will say, okay, so what plan for the affidavit? Your position is there. And then we call so that I can reach out. So it was on this basis now judge no make judgment. Now Martininda now goes to court to say that the date for the Gazette no 24th December. And by the reckoning, you know, that would also mean that it is within the 21 days after the election. December 7th, it's 24th December. Which a timeline now, Electoral Commission, or see, this is the Gazette way. So, for all intents and purposes, and based on good faith, bona fide, yeah, can see okay, we will mount the petition based on your 6th January. After judgment, no court here will be and now go Supreme Court. So that be Supreme Court, that be. The truth of the matter, say, the Gazette date is December 24th. And because it is December 24th, no, I judge before. At the time, our NDC candidate, no, mounting the second petition, no, 21 days now per month. And so, to the extent that 21 days no upon no one year. Any petition filed after the 21 days is considered incompetent. If the petition is incompetent, then you cannot mount a successful judgment on it. Because then the jurisdiction of the High Court was not properly invoked.
Now, me you know, ye learned judges at the Apex Court. No, one more answer the working chronology of these events now it leading to say the High Court can't say woman to a ban from.
In fact, that is one of the things we want to read in the judgment. Almost said the judgment will be available in February. I personally want to know how the Supreme Court resolved the timeline issues. I want to know how the majority decided that, okay, notwithstanding the affidavit in support of the motion to strike out the original petition, notwithstanding the fact that Martininda Nankasa and the High Court swore to, it's like he's taking an oath and said this is what it is. And based on that, A, B, C, D has been taken. It's based on that, the petition was premature. I want to know how the respected justices of the Supreme Court, the majority, resolved the issues of timeline. Because the whole case before the Supreme Court was on timeline. It is either the Supreme Court accepts the 24th December or the Supreme Court accepts the 6th January. Martininda Nankasa at the bar court no. But you see, much earlier no, there was a previous decision of the Supreme Court, in the case of the Republic versus High Court, Koforidia, I think it's a contempt matter involving Nyaminia, the late Yaokumi Enes. May his soul rest in peace. And to usher the case of the Republic versus High Court 3, Koforidia, Espati Enes Yaokumi, applicant Henry Boate Yado, first interested party, Electoral Commission, second interested party, the Clerk of Parliament, third interested party. Again, by a majority decision comprising Professor Mensa Bonsu, Gaiwu Kofi, Ajay Frimpong, my Lord Ajay Frimpong, in the throw the decision.
Council, and yeah, where your mammy train. Now, Matthew, simple person called review. Now, review. Okay, yeah. Can a year lawyer Judy Tamakrubium. Council, Miss Amokwaba.
Yes, in Tibet, you see a case now involving my big brother and me. In that case, no, the majority, and let me read a portion of the ruling. This is what the majority said in the NS committee decision. Or say, quote, the central issue in this case, therefore, was when was the result of the Akwitia parliamentary election gazetted? It is no cancer. If they have to resolve the central issue when the gazette was, when the election result was gazetted, all the other issues will be resolved easily. So the court set that question to resolve. In a court of say, this could only be a simple question of fact, even though the gazette notification carried a legal effect. Affidavit evidence. In his affidavit in support, the applicant attached Exhibit D, an extract of the gazette notification. On the extract, the date of the gazette was stated as 6 January 2025. The first interested party filed a further supplementary affidavit in opposition on 11th day of March 2025, in which he deposed to quote that I have caused my lawyers to conduct a search at the Ghana Publishing Company Limited, Assembly Press, the official and only publisher of gazette notifications in Ghana, to verify the authenticity of Exhibit D attached to the applicant's affidavit in support. Attached and marked as Exhibit 11 is a copy of the said letter. That the Ghana Publishing Company replied to the request by my lawyers and stated that the said Exhibit D by the applicant is not genuine and cannot be found in the records of Ghana Publishing Company Limited. Attached and marked as Exhibit 12 is the said response from Ghana Publishing. What so this is where the Supreme Court said, if the lawyer for the respondent in the NS communication, which is the NDC candidate who looks to NS communication, on how can the search in a Ghana and Accra State, the 6th January Gazette, they cannot find it in their record. Then effectively, quote unquote, it is fraudulent. That's why it is fraudulent. So the court now proceeded to say, from Exhibit 11, the first interested party attached 2 separate gazette notifications. The applicant's Exhibit D dated 6 January 2024 and the one he had procured for Ghana Assembly Press, that is Gazette number 234 dated 24 December 2024. Based on that, in the NS case, the Supreme Court now came to the conclusion, say, if that is the case, then the proper Gazette date will be 24th December. And that is what the NDC in this is delivered here. Now, as I say, for constitution said The sixth January, the South Asian so can't say, no, premature. It was wrong.
Oh, okay,
so
to sure.
I realized that in the family decision, in the family case to withdraw applications, were in error. And that error will work against us. Unfortunately, that's how things turn out.
Now, yeah, to say, Muslim review.
Don't panic. As a lawyer, and as I actually, we are trying a copy of the decision. Again, we would want to see how the majority resolve the issue of the timeline. Why the preference of the 24th December date over the 6th January, even though the applicants, like in the instance case, relied on that 24th, relied on that 6th January 2025 Gazette date, as the basis to act as the petition, earlier petition was premature. We want to see how the Supreme Court went about it, because this fundamentally an application to Sharia is discretionary. So the conduct of the applicant is a deciding factor. Yes, it may well be that the court in the earlier decision, that is ex parte and ex commis, has resolved the issue that 24th December is the proper date of the Gazette for election 2024. That being the case, the position is to the extent that matching in them echo and coast and rely on that 6th date one, it still benefit from that representation from the court. Because the question, who are the country issue? 6th January is the proper date. Now, okay, Mate. 6th January, and the other may withdraw the one I'm filing based on the 24th December. Now, you're so proper into the case. Now, what tell me about that? Even you, it has come to attention that the Supreme Court has in an earlier decision now upheld or taken the view said 24th December, and for that matter, the judgment that was validly procured based on the 6th January Gazette notification was made in error. We shall say the conduct of the applicant hearing the Honorable Martin Yindam ought to have been a deciding factor, but the majority were of a different view, and under the circumstance, we can only disagree. And once we get the benefit of the full judgment, what we'll do is to advise ourselves what the next line of action will be.
I see. Kazo mame na wase na me nsenya mpama. E kina so ye soro koda.
Welcome better to Papa. Last into me chair old man.
Dedi kama mame na PENDREAM TV ase. Na so far so good. Say open online portal e wo Ghana. Ah nipa share, nipa follow, nipa comment here. To my best of knowledge, without any biases, PENDREAM TV.